Good evening to all of you.
Good evening.
United Nations Day wishes to the brothers and sisters world over. The theme of the United Nations today is Building Back Together for Peace and Prosperity. This day is a historic day for humanity. The United Nations is the preeminent institution of multilateralism. It provides a forum where the sovereign states can come together to share burdens, address common problems, and seize common opportunities. All countries, big or small, strong or weak, are equal members of the United Nations. Whatever its flaws, the United Nations is still the only institution that brings together all the countries of the world. It highlights the glorious functioning of this global institution for 76 years. Today, we are talking about peace, justice, and development. Peace, unity, love, and non-violence should be our rallying cry and a catalyst for the change in our nation. That is all non-violence is, that is called organized love. It is none other than our Dr. V.R.S. Sampath, who is organized the love of the whole world today through this conference. My special congratulations and wishes and respect for Dr. V.R.S. Sampath. And I convey my special wishes to the Honorable Minister for Law, who has inaugurated this conference, Honorable Chief Minister, who has given a very meaningful message to the conference, and Brother Justice Bhaskaran, who has inaugurated this conference, and all the allied speakers who will be speaking shortly. Justice and development go together. Development and disputes are the two sides of the same coin, which means that the alarming rate of development has its snag, which is the increasing number of disputes in various sectors. The United Nations, speaking through the Secretary General Ban Ki-moon, says, sustainable development is the pathway to the future we want for all. It offers a framework to generate economic growth, achieve social justice, exercise environmental stewardship, and strengthen governance. The people craving is for justice. The craving for justice has been an ideal for which the mankind has been aspiring for generations down the line. Our constitution reflects this aspiration in the preamble itself, which promises justice in all its forms, social, economic, and political. But according to the data released by the Honorable Supreme Court in June 2020, 3.27 crores cases are pending before Indian courts, of which 85,000 has been pending for 30 years. There is no greater tyranny than that which is perpetuated under the shield of law and in the name of justice. Martin Luther King said, injustice anywhere is a threat to justice everywhere. We are not satisfied and we will not be satisfied unless and until justice rolls down like waters and righteousness like a mighty stream. This is what the people expect. When we talk about pendency, it does not mean that the judiciary is lagging behind. The E-Committee of the Honorable Supreme Court of India is taking enormous steps to liquidate the pendency in whatever way possible. It has resorted to digital justice delivery. The information technology and businesses today are becoming inextricably interwoven, and I don't think anybody can talk meaningfully about the one without the other, so said Bill Gates. The E-Committee of the Supreme Court has so far taken digitization of judiciary in 3 phases. The 3rd phase is in progress, and it is taking steps for ecosystem approach where seamless exchange of information is possible and uniformity and standardization of data is done, and 360-degree profiling of each and every individual is also done, but it has got its own challenges. We have no time to elaborate on this. Suffice for me to point out that enormous steps are underway and it will ensure speedy justice, but that step alone may not be possible to liquidate the pendency. Coming back to what is the alternative to this kind of huge pendency? Then it is alternate dispute resolution. And when we talk about alternate dispute resolution, it is also arbitration, which is one of the method of alternate dispute resolution. The ADR mechanism provides scientifically developed techniques to Indian judiciary, which helps in reducing the burden on the court. ADR provides various modes of settlement, which includes arbitration, conciliation, mediation, negotiation, and lok adalat. Arbitration is a procedure in which a dispute is submitted by agreement of parties to one or more arbitrators who make a binding decision on the dispute. In choosing arbitration, the parties opt for a private dispute resolution procedure instead of going to court. I am making it a little bit slow because our main subject is arbitration. Arbitration is a preferred method as it is more rational, more just, and more humane than any other violent means of resolution. It is also consensual. The very umbrella of term arbitration are explained by two of our very eminent leaders, one by Mahatma Gandhi, our father of the nation, another one by the 16th President of the United States of America, Abraham Lincoln. About arbitration, Mahatma Gandhi said, I had learned the true practice of law. I had learned to find out the better side of human nature and to enter man's heart. I realized that the true function of a lawyer is to unite the parties involved in a dispute. The lesson was so indelibly burnt into me that larger part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, and certainly not my soul. Abraham Lincoln, the 16th President of the United States of America, he was in favor of arbitration when he said, I quote, discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser, that is in fees, expenses, and waste of time. Nothing can be said more elaborately or more succinctly than the two leaders have said about that. But I will little bit elaborate on the efforts taken by the Government of India and the Government of Tamil Nadu to enable ease of doing business for those persons who are wanting to invest in India. The Government of India is pushing forward the concept of Make in India and converting our country as a major player in the world market, for which we need to come out with an enabling business-friendly environment. Our Chief Minister has gone a very further step and said, wherever we move across the world, wherever we see any object, that should reflect that it is made in India. That is the vision that the Honorable Chief Minister is having. In a liberal economic era where the boundaries of nations have become redundant in the business world, allowing free trade and commerce in the global world is the motto and goal of today's good governance. And with the increase of trade and commerce, naturally the commercial disputes are also increasing. What is our duty and responsibility? It is our duty to provide speedy, cost-effective, and fair settlement of commercial disputes, preferably in an informal way. That is the key for becoming leader amongst the developing nations. The Supreme Court already has said that wherever there is a possibility of settlement, it is a duty of the court also to refer the matter to mediation or arbitration or any one of the ADR methods. That is said in 89 CPC and in the Civil Procedure Code Order 32A Rule 3, apart from Section 12 of the Industrial Disputes Act, are also speaking about those kinds of ADR methods. What I'm trying to tell you is not that the Act alone, Arbitration and Conciliation Act alone speaks about that. Even prior to that, long before, our law has recognized this kind of alternate dispute resolution methods. Coming to Arbitration and Conciliation Act of 1996, that there are four fundamental philosophies, which is very, very important for us to appreciate and understand. The four philosophies are party autonomy. Party will have the liberty of choosing their own person who is to judge my case. Party will have that liberty. What else is needed? Expeditious disposal, number 2, minimum judicial interference, number 3, and finality of the arbitral award. These four basic philosophies are available in the case of arbitration. That is the basic of it. Where is the commencement of arbitration? And we know that there are many tribunals which are statutory. For example, Motor Accident Claims Tribunal is constituted under Motor Vehicles Act. It is statutory. So far as arbitral tribunals are concerned, it is only the private parties establishing their own tribunal. That is the prerogative available under the arbitration. Though after the Constitution and even during the Constitution, court will have some kind of interference or some kind of facilitation, but it is purely based upon two contracting parties deciding to choose to go for arbitration and for establishment of arbitral tribunal. Section 7 of the Arbitration Act states in an arbitration agreement, which is expected to be in writing and it may be in the form of any form of writing, maybe exchange of letters, telex, telegram, etc., etc. 2015 amendment specially permits creation of arbitration agreement through electronic communication. That is, I am also just pointing out how the law is developing with the advancement of technology by side. There are some of the subject matters which are, some are arbitrable and some are not arbitrable. Before entering into this arbitration agreement, one should be very clear about that. Unenforceability should also be taken care of. Who can be an arbitrator? Section 11 is very liberal in saying that a person of any nationality may be an arbitrator unless otherwise agreed by the parties. Here also party autonomy alone speaks. The challenge to the arbitrator can also be made by the parties, but a very beautiful provision is there which says the challenge to the appointment of arbitrator can be decided by the arbitral tribunal itself. That is the special beauty about that. What are the disputes that are non-arbitrable? Unless it is arbitrable, we will not have the facility of arbitration. This is very important. Therefore, I am only giving the broad categories. Dispute relating to rights and liabilities arising out of criminal offences, number 1. Number 2, matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights, guardianship matters, insolvency and winding up matters, matters relating to public charities or public charitable trust under the Public Trust Act, testamentary matters, eviction or tenancy matters. The underlying factor behind this is wherever the right in rem is involved, the disputes are non-arbitrable. Where rights in personam is involved, the arbitrations are freely allowed. That is the only thing. What are the advantages of having an arbitrator? The parties can agree on the procedure for conducting the arbitration proceedings. The Code of Civil Procedure is not applicable. When no procedure is agreed upon by the parties, the tribunal is authorized to conduct the proceedings as it considers appropriate. Even when the parties are going to be silent, the tribunal will not take away the Code of Civil Procedure for deciding the dispute. The procedure that is agreed upon is which the arbitral tribunal considers appropriate. The tribunal is expressly exempted from applying the provisions of Civil Procedure Code and the Evidence Act. Both are not applicable. It is only the appropriate procedure. Wherever there is an arbitration under the arbitral institution, maybe the rules of that institution which will be applicable. Having said that, CPC is not applicable, Evidence Act is not applicable, and the parties will have so much of advantage. The result that is, or advantages accruing to the party is the privacy of the dispute. It is less expensive. Finality is attained at the early point of time. It suffices to point out that it is less complicated, less complicated. When it is less complicated, parties will understand the case in a better way. Where is the commencement? Section 21 provides that in the absence of an agreement between the parties, the arbitral proceedings in respect of a particular dispute shall commence on the date on which a request for the dispute to be referred to arbitration is received by the other party. Commencement is there because when we speak of finality, starting from that point, finality comes at an early point of time. We have already said that it is Evidence Act is not applicable. Confidentiality is ensured by 2019 Amendment Act. There are 3 amendments for the 1996 Act. One in the year 2015, another in 2019, another in 2021. There are 3 amendments. And the Government of India is very particular that the law should be updated, law should be up to date, and so that the ease of doing business is not in any way affected. Confidentiality is ensured under the 2019 Amendment Act, which has introduced Section 42A, which speaks about confidentiality of information. What is when we talk of arbitral tribunal, what are the powers? There are powers under the Section 17, which power is equivalent to same powers as that of the court in respect of interim measures. Whatever is the nature and type of remedy that could be granted by the civil court, and equally the tribunal is also entitled to grant it. Therefore, nothing to worry about that. Most important is, as we all know, speedy trial is the fundamental right of any person who is aspiring to get justice in a court of law. Under Article 21 has been interpreted where the Honorable Supreme Court said speedy trial is the fundamental right. Here, when we talk about the expeditious disposal as the fundamental philosophy or arbitration, where are the provisions? What are the provisions? Very important provision is time limit is set up under Section 29A. The Arbitration Act provides for a time limit of 12 months for the arbitral tribunal to decide and make the award. That is 12 months. This period can only be extended by another 6 months upon the agreement by the parties. See the consequence. If the award is not made within a period of 6 months, what is going to happen? The mandate of the arbitrator stands terminated. See what kind of stringent provisions to ensure that the justice is timely, justice is speedy. And if the award is not going to be within time, mandate of the arbitrator will get terminated. Section 29A also states that where the award is made within a period of 6 months, arbitrators are encouraged and they are entitled to claim additional fees from the parties. And if it is not going to be within the time and it is going to be extended, there is 5% reduction of the original fees also. These are the provisions ensuring that it should be timely. The next question is, when it is timely, where is the scope for finality? When it comes to finality, there are only limited grounds available to challenge the award under Section 34. It is not an appeal, it is not a review, it is not a second appeal involving substantial question of law, not like that. Very limited judicial review under Section 34, limited grounds. That is available for setting aside the award. There is only one appeal after the award is confirmed under Section 36. Then when those kinds of impediments are there, then naturally finality will be coming to an very easily. I will just mention only the grounds of challenge of the award, which is very important. Only on the important aspect I am just elaborating, not on everything. It is incapacity of a party, the arbitration agreement being invalid under any law, improper notice of appointment of arbitrator, the arbitral award decided on a dispute beyond the scope of reference to arbitration, the procedure for composition of the arbitral tribunal or arbitral procedure was not in accordance with the agreement of parties, the subject matter of dispute is incapable of being settled, the arbitral award is in conflict with public policy, it is affected by fraud or corruption, or it is in contravention of the fundamental policy of Indian law or basic notions of morality or justice, or it is in violation of confidentiality and admissibility of evidence. These are all the grounds on which the award can be challenged. Then the appeal is also on a very limited ground. And the only thing I wish to point out especially is this amendment, especially the 2019 amendment, arbitration towards institutional arbitration. The statutory mandate of establishing Arbitration Council of India is another step towards formalization of arbitration in India, with the council having powers to grade arbitral institutions and recognize professional institution providing for accreditation to arbitrators. These are the very essential provisions and very essential steps which are taken by the Government of India and the Government of Tamilnadu also to ensure ease of doing business and to ensure dispute resolution through methods which are non-violent, through methods which are establishing the relationship between the parties, not breaking away the relationship for the sake of money. There was a conversation between the heart and the brain. The brain asked the heart, why are you going on sending messages to people? Laptop, always sounding laptop. The heart immediately responded saying, as a brain, you may require reasons, but as a person, as a heart, I want a relationship, and therefore I am going on sending messages to people whether they want it or not. The message through alternate dispute resolution is that peace and harmony is possible, and your dispute will also get settled through peaceful methods. And all people are by nature, they are peace loving and they are peace enjoying. Peace only ensures development. Therefore, let us resort to alternate dispute resolution methods, especially arbitration. Thank you very much for the wonderful opportunity given. Thank you so much.